What is Actus Reus? Other than often misspelt by law students everywhere, myself included when I was writing the script. R-E-U-S, not R-E-A-S for the record. Frankly though, it might not even be spelled correctly in the title of this video. Latin enjoys my suffering. Disclaimer, this video is intended for academic and entertainment purposes. Nothing within this video constitutes legal advice. I am not a lawyer. I am a recent LLB and diploma graduate, and this video is intended to help other students on their journey. I may be wrong on any and all of these points, but I have tried to be as faithful as possible to my original lecture notes and my own understanding of Scots law as a successful student. Case citations will be found in the description. Actus Reus is actually rarely discussed in and of itself because it has a fun twin that everyone likes to talk about in their papers. I'll do a separate video on mens rea because you really could write your dissertation on it, but the two form an interlocking basis for criminal liability. An accused must be shown to have both actus reus and mens rea before they can be convicted of an offence. In general, there are exceptions because nothing in law is that simple, ever. Mens rea represents the necessary mental element of the crime. It's what separates murder from culpable homicide. Actus reus, on the other hand, is the physical conduct performed to facilitate a criminal offence. Thinking about theft is not a crime if you never steal anything. We don't live in some Orwellian dystopia. You can't commit housebreaking by just really concentrating on a house across the street. You have to physically take yourself across the road and break in. Actus reus is therefore quite a broad general concept because every crime has an actus reus associated with it. There are some situations where conspiracy alone is a crime, and initially people tend to want to view that as a crime of mens rea alone. The crime hasn't been committed after all, just thought about, but legally that isn't the view taken. Bringing a second person in and making substantial, tangible plans towards the facilitation of an offence is the actus reus. You can't really conspire with yourself, and bringing in another party suggests a serious intent to go through with the offence. In spite of the scope of actus reus and the difficult to spell legalese, I think intuitively most people understand the core idea quite easily. The actus reus of assault could be punching another individual, for reset it would be selling a stolen item, and for driving without due care and attention it would be sending a text message, for example. These, it should all be noted, are voluntary acts. There are such a thing as involuntary acts. These are usually external events or reflex actions. See Hill against Baxter in 1958. The defendant in that case was found guilty due to insufficient evidence to support his defence of automatism, which I'll discuss in more detail some other time. But the case supports the general principle that an involuntarily committed actus reus is no actus reus at all. So, for example, if a person is sleepwalking and punches another individual because they're fighting off an assailant in their dream, a court may well find that the accused lacks the requisite actus reus for assault. Though sleepwalking in general is a bit of a contentious subject, so it might be easier to steer clear of that and instead think of a large man having a violent sneeze, who then accidentally knocks into a smaller person and causes them to fall over. He's not committed assault, because his conduct wasn't a voluntary act or omission. For obvious reasons, this doesn't come up too frequently in court. No one is being charged for overly violent sneezing. When it does arise, it's usually an off-kilter defence to a more serious crime. There is one more caveat, and it's that external factors that mitigate actus reus cannot be self-induced, and the person cannot have been bound to foresee it, as per Ross against H.M.Advocate in 1991. There should be little to no chance for reoccurrence. So, for example, being blackout drunk does not mitigate actus reus, unless the individual didn't knowingly consume the alcohol. More commonly in spiked drink defences, it's drugs being unknowingly added to an accused's alcoholic drink while at a bar or a club. They didn't voluntarily consume the substance, so when they decide to try out a wrestling move they saw once on the bouncer, that's not voluntary either. This is at least true in theory. Courts don't tend to accept this sort of defence lightly, and they've added various additional factors over the years, such as needing a causal link between drugs and the criminal behaviour, or needing to show that the accused was truly ignorant to the state of affairs. You could always try and differentiate your case from those precedents, but I think you would struggle as there's no alternative rulings I can think of that suggest circumstances where the court wouldn't wish to be satisfied with these facts. The last thing I'll touch upon, though I did mention it very briefly before, is omissions. Stuff you don't do, and my favourite thing, because I love not doing stuff. However, in some circumstances, failure to act can be necessary actus reus to a crime. If you have a responsibility to act a certain way and you fail to do so, that may constitute the actus reus of an offence. Usually this is because you have a duty of care to someone or hold a certain office that necessitates action. For a more specific example, see Hogg against McLeod 1983. A senior police officer was found guilty of being art and part in an assault. Art and part liability is sort of like the charge of accessory that other jurisdictions have, but not quite. Where two or more people engage in a crime together, each of them are guilty of the whole, regardless of which particular role they had in the offence. A junior police officer had assaulted a prisoner in front of this particular senior officer, and he had failed to stop the assault when he had a legal duty as a policeman to protect the prisoner. In fact, he had even taken part to the effect of quote-unquote quick marching him down a corridor after the initial officer had physically injured him. His omission to stop the junior officer made him part of the crime because he should have intervened. Omissions can also give rise to actus reus wherein the accused caused the initial problem in the first place. See MacPhail against Clark, 1983. The accused in this case was a farmer who had set fire to some straw in his field, which subsequently led to smoke blowing over a nearby road. This reduced the visibility on the road and led to a collision. As the farmer had done nothing to stop this fire, he was shown to have culpable negligence and he had endangered the lives of road users. His omission to try and put the fire out for over 20 minutes constituted a reckless indifference to the danger he had created. There does have to be a causal link between the omission and the consequence. This is true for actus reus in general. Normally, the rule is that the accused is held to have caused near and natural consequences, but not anything resulting from novus actus interventus. In simple English, a new act intervenes, which breaks the chain of causation. An existing medical condition of the victim isn't a novus actus. The thin skull rule, if you like, is that you take your victim as they are. Most people could be punched and live to tell the tale no worse off, but if by chance an accused is unlucky and they hit someone once and that person then dies, it's bad luck. They still perform the actus reus of murder, or at least culpable homicide. What is novus actus is generally something completely out of the realms of the accused's control. An act of God or force of nature would suffice. That isn't to say the accused prays really hard for the fiscal to drop the case, but that an earthquake that kills the victim after an assault takes place is within exactly nobody's control. Therefore, no one can be liable for it. More realistically, an act of the victim or a third party would also suffice as a novus actus. If the same assault victim instead gets into an ambulance and they go to A&E, but a third party driver crashes into the ambulance and they die in a road traffic collision, the accused cannot be liable for this death. This is in spite of the fact the victim would not have been in the ambulance had they not been assaulted. This is not the case where the victim comes to harm or to death in trying to escape the accused. See MacDonald against H.M.Advocate 2007, wherein the victim jumped to his death from a third floor window while trying to escape his attacker, who allegedly locked him into a flat. There was an appeal where the matter of the locked door was called into question and it wasn't really resolved upon because it wasn't essential to the Crown case, hence why I'm saying allegedly. Allegedly, this is also the end of the video. I haven't fully decided how to end these videos actually, but if you enjoyed this was helpful in some way, I'll be posting more of these when I have the time and energy to do so. Mens rea will be next because it's so much part of this topic. After that I might do art and part in more detail since I mentioned it too. I'm not particularly sure, though I do have a general plan of working my way through topics from my first year through the fourth year of my LLB, and then touching on topics that I covered during my diploma and that are maybe a bit more complex. I did mostly elective modules that were criminal law based, so that's what I know best and feel comfortable passing on. So if that's interesting to you, maybe stick around and subscribe.